Hey guys, today we're going to talk about financial distress and the signs of financial distress and what a firm can do. It's one of those topics that we typically don't get to in some of the earlier classes, and it's important because especially in recessionary times we see a lot of companies that are experiencing difficulties. So financial distress there's a couple of different forms. One is where your operating cash flows aren't enough to satisfy your current obligations, so you need to do something to correct. So you don't have enough operational cash flows. And another is the default, in that you need to do some level of restructuring with your equity and creditors. So a stock-based insolvency says, when we look at the balance sheet, typically the asset side, what we own, is equal to how we paid for it, debt plus equity. For an insolvent firm, the debt is greater than the assets. In other words, the company has negative equity. This should seem familiar to you. You've just been looking at a balance sheet with this situation in Rosetta. Rosetta is technically a stock-based insolvency. You've got to be a little bit careful when you look at insolvencies because Rosetta is a perfect example. It's a private company. The equity holders are a couple of partners. They're willing to be underwater. So this is strictly a stock-based insolvency. Their flows are fine. So this is a flow-based insolvency where you're not bringing enough operating cash flow to cover your contractual obligation. That's not the issue with Rosetta. The issue with Rosetta is that they just need to adjust their capital structure over time. But a flow-based one is serious, and that is when we think back to the cash flow statement, the cash flow from operations, they're typically negative in this situation where you're producing product and you're not even covering your costs on producing your product, and those companies are more likely to either do some substantial restructure or face some serious issues. Here's some of the largest bankruptcies, and you'll see some of these companies still exist that they did not liquidate, but you look at Lehman Brothers, and they were $2/3 of $1 trillion in terms of the size of the liabilities when they went under. General Motors and Chrysler clearly are still here, but Chrysler, the way they survived is by a buyout from Daimler Chrysler. Daimler Chrysler. So what happens in financial distress? It's not always that the company needs to shut down. You need to figure out a way to get some cash. And so there's lots of different ways to do it. You can lay off a lot of people. You can sell assets. You can work on a merger that was the Sears Kmart model that has worked for a number of years, even though it's struggling now. You can cut your capital spending and your research and development, so cut some of those assets you've been investing in. You can issue new securities. You've got to be a little bit careful about this because issuing new securities, if you're in financial distress, your stock price is usually pretty low, so you want to be careful about issuing a lot of undervalued shares. You're not going to get much money for new securities. Most commonly, you negotiate with banks and your creditors to try to improve terms. This particularly becomes important when we've seen big movements in interest rates. So if interest rates were high when you took on that debt and they've been reduced, oftentimes you have a better likelihood of negotiating terms. Or if the interest rate was high because the financial picture was a little unknown. If you were an early stage company and you're 20 years into it now and you've established a record, even though it's not going great, you may be able to reduce some of those terms on some of those longer term bank notes. You can do a swap of debt for equity. Oftentimes it's taking your junior creditors and swapping that debt for preferred equity, often with a conversion factor. And then you could, of course, file for bankruptcy. This was a nice article that was written a few years ago, and the colors aren't great on it. But in general, so when a firm is experiencing financial distress, almost half of them, 49%, don't do any kind of restructuring. Of the remaining 51%, half of those guys work it out privately, so it never goes to the court. You just work with your creditors and do a restructure. I'm working with a company right now that is exactly in this point. So it's the financial position is not going forward. It's not a going concern, but the terms on the debt are such that if we can amend and then extend the length of time, it's called an amend and extend. So change the terms so we lower the interest rates and typically push out the date extend the date before you actually need to completely pay back the obligation. Oftentimes you can work this out and avoid the courts altogether. However, in about half of the cases where there is financial distress, most of them reorganize and emerge. You often hear about companies in Chapter 11 bankruptcy. They typically are taking the 120 days and trying to broker deals with their debt holders and sometimes their equity holders, and then they reorganize their financial situation and then emerge from bankruptcy and emerge as a going concern. In some of the cases, companies merge, so they seek another partner to keep them going, and then only about 10% of those cases actually are liquidated. It takes a bit for a company. You often see companies go through Chapter 11 bankruptcy 2 and 3 times before they ultimately get to the point where they're liquidating. You're seeing Sears right now. They've been in at least twice and maybe more than that now in Chapter 11. And what are they doing now to preserve some value is they're selling off assets, and that's an attempt to remain viable for a bit longer. So if you're struggling with financial distress, you've got 2 things. You can look at the asset side or you can look at the financing side. So as we said earlier, if you're looking at the asset side, sell some assets. That's what Sears is doing now. Sell those locations and bring in that capital to help pay down some debt. You can merge. It's not done as frequently, but you can. And then you can reduce what you're spending on capital assets. So stop buying fixed assets, stop investing in R&D. There's longer-term ramifications for this, because if you cut back on what's creating value for your firm, that is a hard longer-term strategy, but it is something that companies do until they can kind of rebalance themselves and then continue to grow again. A financial restructuring says you can issue new securities, not done as frequently because the stock is undervalued and you're just diluting the value of the existing shareholders. Very frequently, you negotiate with the bank and the creditors. You exchange debt for equity. Typically, you take the debt holders and you exchange that debt for preferred equity, and then, of course, you could file for bankruptcy. If we go through bankruptcy, you can liquidate or you can reorganize. A liquidation is called a Chapter 7, and that means the firm's not going to exist anymore. Typically, it's not a first step. You typically start with a Chapter 11, but with a Chapter 7, you sell the assets, you salvage, and then whatever you get rid of whatever you have to pay in transaction costs, the excess is distributed to creditors first in order of priority. If there's anything else, the equity holders get the remains. A Chapter 11 means you're going to continue on, and you typically it's involves reorganizing. You are going to issue new securities to replace the old, so you're reorganizing as a going concern with a different set of equity. So when you go through a Chapter 7, you file with the courts, and they create a trustee to help work on selling off the different assets and liquidating the firm. You pay the administrative costs first, and then your creditors get remains, and then if anything is left, shareholders get what's left after the debt holders have been paid. Now, this is the order of priority. It's not done perfectly this way, and we'll see why in a minute. So first is, I always joke that it's the lawyers get paid first. So it's the administration expenses associated with the liquidation. It's the lawyers. Now, the unsecured claims that arise for filings after the involuntary bankruptcy petition. So only if it's an involuntary bankruptcy petition, in other words, the owners are not filing the bankruptcy, but the creditors are forcing it, unsecured claims rise up in priority. Then we protect the workers, and so the wages are protected for 90 days, and pension plan. This was really big from back in the 80s when the banks all failed. People were wiped out of their pension plans. So the rules were changed a bit to push the priority up to keep companies from being able to liquidate what they've put into pension and decimating retirement plans for their workers who are now also going to lose their jobs. After the employees, then we go to customers. The consumers have claims, and then, of course, government gets their tax money. Then we get to the creditors, and then we get to the shareholders in order, so preferred over common. Now, while this is a good theory, it's not done. It's not held to entirely. So we say that these are the guys who get paid first, but the reality is a little different. So equity holders, in general, you should get paid pennies on the dollar, but they are paid out far more often than we think. Now, they're not paid in full, but they're paid out far more often, and we'll see why in just a second. The unsecured creditors are those that just have debt, but it's not tied to an asset or anything that can be sold, and then the creditors get the proceeds. The unsecured creditors actually are paid out quite frequently. Oftentimes the unsecured creditors are paid before the secured creditors, which is not what's supposed to happen. And the secured creditors do pretty well. But in general, now they should be paid pretty close to in full, and they get pretty close to in full payment. So why do we violate the absolute priority rule? Well, a number of things. One, a lot of this is done without involving the courts, and so you make deals. And so as you're making the deals with the creditors, they'll take terms different. So even a secured creditor, again, the company I'm working with right now has a $182 million investment in this firm, the creditor does, and it's secured with some of the equipment. They have every right to force the firm to sell the equipment, but they won't, because it's worth more as a going concern than it is liquidated, and so therefore they're willing to take some amount less than the full value for their secured investment. So this firm's not liquidating, but instead what they're doing is they're renegotiating terms. So oftentimes creditors just want to skip the whole litigation stuff, and so they'll take different terms. Now, a big one is that while equity holders should have very low priority, because managers very frequently have equity, and because for the first 120 days they're in charge, they often create terms that are beneficial to equity holders. And then finally, the bankruptcy judges are not looking for a long, drawn-out process that allows the attorneys to get a lot of money. Instead, what they're really looking to happen is to come to agreement. So enforce and really pushing compromise, the absolute priority rule is very frequently violated. So if we have a bankruptcy for a Chapter 11, which we're typically not liquidating, we file a petition, the judge approves it, the business continues to run. It's often a challenge. I remember when Kmart went into its bankruptcy early on. I'll never forget, I walked into a Kmart to buy some Rubbermaid products for the kitchen, and they no longer were allowed, they couldn't carry Rubbermaid anymore. So they got some cheap brand that they were carrying instead of Rubbermaid, because Rubbermaid refused to deliver inventory to them any longer. And so often when you're in Chapter 11, you'll find some of your previous suppliers will no longer supply you. And so while they are continuing to run the business, there's often some tweaks to the business because of relationships that have been damaged given the bankruptcy filing. So the firm has 120 days to reorganize, to create a plan, and you divide the creditors and shareholders into classes. Now here's one of the challenges. That in order to approve the plan, only half of the creditors have to agree, but that half has to own 2/3 of the debt. So if you're in the minority and you completely disagree with the terms, you're out of luck. If half of the creditors have agreed to the terms and they own the majority of the debt, then you are forced to comply with the new terms. So you may have 12% debt outstanding on this company, and some of the other creditors agree to terms where it's reduced down to 6%. That's all you're going to get, and there's nothing you can do about it. Once the creditors accept, the courts just confirm, and then you just go through the process of making payments to the creditors and shareholders over time. Oftentimes in Chapter 11, you'll see if the company was paying a dividend, that's removed until creditors get as close to whole as they're going to get. So what works best for a bankruptcy? Personally, I believe the private workouts are better. It's less expensive for all of the vested parties because you're not paying all the attorney fees. And most creditors are not looking to liquidate. They, as long as there is positive cash flow, they would rather see the operation continue, and typically they'll negotiate the terms. Okay, so ordinarily the existing debt and equity in in the company. When the company files bankruptcy, they're reissued. So all of the old claims disappear and we have new claims. So senior debt is often, most all of the claimants move down a category. So senior debt becomes junior, and then the junior debt is often converted to preferred equity. Again, as I said, that ordinarily working something out is better than a bankruptcy. But if you have a highly complex structure, the private workouts become more difficult. Personally, I don't find that. I think even with very complex structures, the individuals, the companies who have participated in creating the complex structures understand what they've gotten into, and they also understand the value of compromising and working out a deal as opposed to going into bankruptcy court. So what's best? The advantage of the bankruptcy is you have new credit issued. You get rid of some of the earlier debt that's been burdensome to continuing on. There are some tax advantages, and again, only half of the creditors have to approve this. The problem with bankruptcy is it is long, it is expensive, the judges are involved. It's very difficult to continue to run business while you're going through bankruptcy because it takes up so much time, and then you may have some difficult stockholders that are causing it to be challenging to continue on. Now, prepackaged bankruptcy is really just side deals before you actually go before the judge. So you essentially work out all of the terms before you go before the judge, and then once the terms are worked out, and then you go into Chapter 11. Any of the holdouts who have been unhappy have no choice at that point because you've made the deal, and so the bankruptcy will go forward despite the objections of others. It's more efficient because you've worked out the terms prior to the judge, so you're not paying all of those attorney fees. So that tends to the deal tends to be a better deal. Now, you've probably heard of Z-scores. Now, the Altman Z, there's two different ones. One for public manufacturing companies, and it gives you a sense for how creditworthy a company is. It's a nice thing to calculate because an Altman Z will give you a sense for whether or not you're getting into a deal that is potentially could be headed to bankruptcy. And look at what you're looking at. You're looking at the company's EBIT. So what are they doing? So how much, what kind of earnings are they able to generate relative to their assets? They're looking at working capital and how much is that growing. They're looking at how well at what their sales are relative to their assets. They're looking at in essence, their market to book value. It's market equity to book value of debt. And then they're looking at their retained earnings relative to assets. And we've got sort of a rule of thumb. So if your Z-score for a manufacturer is below 1.81, chances are not good that things are going to continue on. You can also calculate a Z-score for private firms. And here we look at working capital, retained earnings, EBIT, and equity to liabilities. For private firms, if your Z-score is below 1.23, it's not looking too positive for you. So that's it on financial distress. I think this will be relevant as you're thinking about Rosetta, and in general, having a sense for what it means when companies in Chapter 7 and Chapter 11 is an important concept in finance too. Have a good rest of the day.